Labor law, fundamental principles and concepts, legal basis, 1987 Constitution, state policies, Bill of Rights and social justice. Q. What are the salient features of the protection to labor provision of the Constitution? A. The salient features of the protection to labor provision of the Constitution, Article 13, Section 3, are as follows. Extent of protection. Full protection to labor. Coverage of protection, local and overseas, organized and unorganized. Employment policy, full employment and equality of employment opportunities for all. Guarantees. Unionism and method of determination conditions of employment. Right of all workers to self-organization, collective bargaining, and negotiations. Concerted activities. Right to engage in peaceful concerted activities, including the right to strike in accordance with law. Working conditions. Right to security of tenure, humane condition of work, and a living wage. Decision-making processes. Right to participate in policy and decision-making processes affecting their rights and benefits as way to provide by law. Share in fruits of production, recognition of right of labor to its just share in fruits of production. Q. What are the rights of an employer and an employee? A. An employer is a person who employs the services of another and pays for their wages and salaries. As such, Article 13, Section 3 of the Constitution provides and guarantees them with the following rights. 1. Reasonable return of investment. 2. Expansion. 3. Growth. On the other hand, an employee is a person who works under the employ of another in exchange of a valuable consideration in the form of wages, salaries, benefits, etc. Article 13, Section 3 of the Constitution similarly provides and similarly guarantees them the following rights. 1. Security of tenure. 2. Receive a living wage. 3. Humane conditions of work. 4. Just share in the fruits of production. 5. Right to self-organization. 6. Conduct collective bargaining or negotiation with management. 7. Engage in peaceful concerted activities including strike. 8. Participate in policy and decision-making process. Q. In her State of the Nation address, the President stressed the need to provide an investor-friendly business environment so that the country can compete in the global economy that now suffers from a crisis bordering on recession. Responding to the call, Congress passed two innovative legislative measures. 1. A law abolishing the security of tenure clause in the Labor Code, and 2. A law allowing contractualization in all areas needed in the employer's business operations. However, to soften the impact of these new measures, the law requires that all employers shall obtain mandatory unemployment insurance coverage for all their employees. The constitutionality of the two laws is challenged in court. As judge, how will you rule? A. The first innovative measure on abolition of the security of tenure clause in the Labor Code is unconstitutional as it goes against the entitlement of workers to security of tenure under Section 3, Article 13 of the 1987 Constitution. The second innovative measure on a law allowing contractualization in all areas needed in the employer's business operations is legal. Article 106 of the Labor Code already allows the Secretary of Labor and Employment not to make appropriate distinction between labor only and job contracting. This means that the Secretary may decide, through implementing regulation, not to prohibit labor-only contracting, which is an arrangement where the person supplying workers to an employer does not have substantial capital or investment in the form of tools, equipment, machineries, work premises, among others, and the workers recruited and placed by such person are performing activities which are directly related to the principal business of the employer. Hence, it would be legal for Congress to do away with the prohibition on labor-only contracting and allow contractualization in all areas needed in the employer's business operations, assuming, of course, that contractual workers are guaranteed their security of tenure. Construction in favor of labor. Q. Clarito, an employee of one, was dismissed for alleged stealing one's wristwatch. In the illegal dismissal case instituted by Clarito, the labor arbiter, citing Article 4 of the Labor Code, ruled in favor of Clarito upon finding one's testimony doubtful. On appeal, the NLRC reversed the labor arbiter's holding that Article 4 applies only when the doubt involves implementation and interpretation of the Labor Code provisions. The NLRC explained that the doubt may not necessarily be resolved in favor of labor, since this case involves the application of the rules on evidence, not the Labor Code. Is the NLRC correct? A. The NLRC is not correct. It is a well-settled doctrine that if doubts exist between the evidence presented by the employer and the employee, the scale of justice must be tilted in favor of the latter. It is a time-honored rule that in controversies between laborer and master, doubts necessarily arising from the evidence, nor in the implementation of the agreement in writing, should be resolved in favor of the laborer. Social justice. Q. May social justice, as a guiding principle in labor law, be used by the court in sympathy with the working man if it collides with the Equal Protection Clause of the Constitution? A. Yes. The state is bound under the Constitution to afford full protection to labor, and when conflicting interests collide and they are to be weighed on the scales of social justice, the law should accord more sympathy and compassion to the less privileged working man. Fuentes versus NLRC. However, it should be borne in mind that social justice ceases to be an effective instrument for the equalization of social and economic forces by the state when it is used to shield wrongdoing. Corson versus Jammer versus NLRC. Recruitment and placement. Illegal recruitment. Q. A was approached by possible overseas deployment to Dubai by X, an interviewer of job applicants to Alpha Personal Services Incorporated, an overseas recruitment agency. X required A to submit certain documents, passport, NBA clearance, medical certificate, and to pay $25,000 as processing fee. Upon payment of the said amount to the agency cashier, A was advised to wait for her visa. After 5 months, A visited the office of Alpha Personal Services Incorporated, during which X told him that he could no longer be deployed for employment abroad. A was informed by the Philippine Overseas Employment Administration POEA that while Alpha Personal Services was a licensed agency, X was not registered as an employee, contrary to POEA rules and regulations. Under POEA rules and regulations, the obligation to register personnel with the POEA belongs to the officers of a recruitment agency. May X be criminally liable for illegal recruitment? A. No. X performed his work with the knowledge that he worked for a licensed recruitment agency. He is in no position to know that the officers of said recruitment agency failed to register him as its personnel. People versus Chodar. The fault not being attributable to him, he may be considered to have apparent authority to represent Alpha in recruitment for overseas employment. May the officers having control, management, or direction of Alpha Personal Services be held criminally liable for illegal recruitment? Yes. Alpha, being a licensed recruitment agency, still has obligation to A for processing his papers for overseas employment. Under Section 6, letter M of RA 8042, failure to reimburse expenses incurred by the worker in connection with his documentation and processing for purposes of deployment, in the case where the deployment does not actually take place without the worker's fault, amounts to illegal recruitment. Prohibited activities. Q. Rocket Corporation is a domestic corporation registered with the SEC with 30% of its authorized capital stock owned by foreigner and 70% of its authorized capital stock owned by Filipinos. Is Rocket Corporation allowed to engage in the recruitment and placement of workers locally and overseas? No. Article 27 of the Labor Code mandates that pertinently, for a corporation to validly engage in recruitment and placement of workers locally and overseas, at least 75% of its authorized and voting capital stock must be owned and controlled by Filipino citizens. Since only 70% of its authorized capital stock is owned by Filipinos, it consequently cannot validly engage in recruitment and placement of workers locally and overseas. Q. Marino Palpak, Eddie Angeles, and Jose Verdugo advertised in the Manila Bulletin the following information: 20 teachers wanted for Egypt. Apply at number 123 Langit, Manila. Salvacion Inocente applied and was made to pay minimal fees to cover administrative expenses and the cost of her passport and visa. For one reason or another, Salvacion did not get the job and filed a complaint with the POEA. Marino, Eddie, and Jose admitted having no license or authority, but claimed that they are not covered by the labor code, since they are not engaged in the recruitment and placement for profit, and at any rate, only one prospective worker was involved. May Marino, Eddie, and Jose be prosecuted? If so, for what specific offenses? A. Marino, Eddie, and Jose can be prosecuted. Recruitment and placement by persons without a license or authority constitute legal activities. Marino, Eddie, and Jose were engaged in recruitment and placement when they advertised that 20 teachers were wanted to Egypt. Advertising for employment is one of the acts considered as recruitment and placement in the Labor Code. That they were not engaged in recruitment and placement for profit does not mean that the conditions for a person to engage in a recruitment and placement found in the Labor Code are not applicable to them. The code applies to any recruitment or placement whether for profit or not. The fact that only one prospective worker was involved does not mean that they were not engaged in recruitment and placement. They were. The reference in the code that any person who offers employment to 2 or more persons as being engaged in recruitment and placement does not mean that there must be at least 2 persons involved. This reference is merely evidentiary. They must be prosecuted for these specific offenses. They already charge fees even if they have not yet obtained employment for the applicant. Q. Wonder Travel and Tours Agency, WTTA, is a well-known travel agency and an authorized sales agent of the Philippine Airlines. Since majority of its passengers are overseas workers, WTTA applied for a license for recruitment and placement activities. It stated in its application that its purpose is not for profit, but to help Filipinos find employment abroad. Should the application be approved? No. The application should be disapproved. The law clearly states that travel agencies and sales agencies of airline companies are prohibited from engaging in the business of recruitment and placement of workers for overseas employment whether for profit or not. In the present case, it is clear that WTTA is the authorized sales agent of PAL, and thus falling within the prohibitions of Article 26. Furthermore, its intention of providing Filipinos with employment abroad will not hold water to approve its application, no matter how noble it is, because Article 26 provides for an absolute prohibition and does not place any merit on the intention of the applicant. Q. Mary Rose Canda's application for the renewal of her license to recruit workers for overseas employment was still pending with the POEA. Nevertheless, she recruited Alma and her 3 sisters, Anna, Chuan, and Mavic, for employment as housemaids in Saudi Arabia. Mary Rose represented to the sisters that she had the license to recruit workers for overseas employment. Mary Rose also demanded and received 30,000 from each of them for her services. However, Mary Rose's application for the renewal of her license was denied and consequently failed to employ the 4 sisters in Saudi Arabia. The sisters charged Mary Rose with large-scale illegal recruitment. Testifying in her defense, Mary Rose declared that she acted in good faith because she believed that her application for the renewal of her license would be approved. Mary Rose adduced in evidence the affidavit of desistance, which the 4 private complainants had executed after the prosecution rested its case. In the said affidavits, they acknowledged receipt of the refund by Mary Rose of the total amount of $120,000 and indicated that they were no longer interested to pursue the case against Mary Rose. Resolve the case with reasons. Mary Rose is still criminally liable for large-scale illegal recruitment. Good faith is not a defense in illegal recruitment as defined in Section 6 of RA 8042. Illegal recruitment is malum prohibitum. Refund of the $122,000 she received does not likewise extinguish her criminal liability. If at all, it satisfies only her civil liability. The affidavit of desistance, moreover, does not bar Miss Mary Rose's prosecution. The criminal offense is not extinguished by such desistance. Besides, affidavit of desistance, as a rule, is frowned upon. Types of illegal recruitment. Q. When is illegal recruitment considered a crime of economic sabotage? A. According to Article 28 of the Labor Code, illegal recruitment is considered a crime of economic sabotage when committed by a syndicate or in large scale. Illegal recruitment is deemed committed by a syndicate if carried out by a group of 3 or more persons conspiring and or confederating with one another in carrying out any unlawful or illegal transaction, enterprise, or scheme, which is an act of illegal recruitment. Illegal recruitment is deemed committed in large scale if committed against 3 or more persons individually or as a group. Q. When does the recruitment of workers become an act of economic sabotage? Under Section 6, letter M of RA 8042, illegal recruitment is considered economic sabotage if it is committed by a syndicate or is large-scale in scope. It is syndicated illegal recruitment if the illegal recruitment is carried out by 3 or more persons conspiring and it is a large scale in scope when it is committed against 3 or more persons individually or as a group. Q. Discuss the types of illegal recruitment under the Labor Code. Under the Labor Code, as amended by Republic Act No. 8042, otherwise known as the Overseas Filipino and Migrant Workers Act of 1995, there are 2 types of illegal recruitment, particularly simple illegal recruitment and illegal recruitment which is considered as an offense involving economic sabotage. Illegal recruitment as an offense involving economic sabotage is committed under the following qualifying circumstances to wit. When illegal recruitment is committed by a syndicate, that is when it is carried out by a group of 3 or more persons conspiring and or confederating with one another, or when illegal recruitment is committed in large scale, that is when it is committed against 3 or more persons, whether individually or as a group. Regulation of recruitment and placement activities. Q. Is a corporation 70% of the authorized and voting capital of which is owned and controlled by Filipino citizens allowed to engage in the recruitment and placement of workers, locally or overseas? No. A corporation 70% of the authorized and voting capital stock of which is owned and controlled by Filipino citizens cannot be permitted to participate in the recruitment and placement of workers, locally or overseas, because Article 27 of the Labor Code requires at least 75%. Q. A recruitment and placement agency declared voluntary bankruptcy. Among its assets is its license to engage in business. Is the license of the bankrupt agency as asset which can be sold in public auction by the liquidator? No, because of the non-transferability of the license to engage in recruitment and placement. The Labor Code Article 29 provides that no license to engage in recruitment and placement shall be used directly or indirectly by any person other than the one in whose favor it was issued, nor may such license be transferred, conveyed, or assigned to any other person or entity. It may be noted that the grant of a license is a governmental act by the Department of Labor and Employment based on personal qualifications and citizenship and capitalization requirement. Articles 27 to 28. Employment of non-resident alien. AB, a non-resident American 6. Entry to the country to work as a vice president of a local telecommunications company. You are with the Department of Labor and Employment, DOLE. What permit, if any, can the DOLE issue so that AB can assume as vice president in the telecommunications company? A. The Labor Code provides that any alien seeking admission to the Philippines for employment purposes, and any domestic or foreign employer who desires to engage an alien for employment in the Philippines shall obtain an employment permit from the Department of Labor. The employment permit may be issued to a non-resident alien or to the applicant employer after determination of the non-availability of a person in the Philippines who is competent, able, and willing at the time of application to perform the services for which the alien is desired. Thus, AB, or telecommunication company, should be issued the above-mentioned alien employment permit so that AB can assume as vice president of the telecommunication company. Q. Phil Northcard Company, a domestic corporation engaged in the optics business, imported from Sweden highly sophisticated and sensitive instruments for its laboratory. To install the instruments and operate them, the company intends to employ Boyha Anders, a Swedish technician sojourning as a tourist in the Philippines. As lawyer of the company, what measures will you take to ensure the legitimate employment of Boyha Anders and at the same time protect Philippine labor? A. To ensure the legitimate employment of Borja Anders, a non-resident alien, I will apply at the Department of Labor and Employment for the issuance of an employment permit claiming that there is no one in the Philippines who can do the work that Anders is being asked to do. At the same time, to protect Philippine labor, I will see to it that Anders will have an understudy who will learn by working with Anders how to install and operate the highly sophisticated and sensitive instruments from Sweden. To protect Philippine labor, the Labor Code provides that the alien employee shall not transfer to another job or change his employer without prior approval of the Secretary of Labor. Training and employment of special workers. Disabled workers. Q. For humanitarian reason, a bank hired several handicapped workers to count and sort out currencies. Their employment contract was for 6 months. The bank terminated their employment on the ground that their contract has expired, prompting them to file with the labor arbiter a complaint for legal dismissal. Will their action prosper? Yes. Their action will prosper. They are doing necessary or desirable jobs and are qualified for the job, and therefore they should be treated like other qualified able-bodied employees. Bernardo versus NLRC. They cannot be terminated simply because of the expiration of the contract. The nature of their work gives them the status of regular employees. What determines regularity is not the employment contract, but the nature of the job. Q. Anna Cruz has a low IQ. She has to be told at least 3 times before she understands her daily work assignment. However, her work output is at least equal to the output of at least efficient worker in her workstation. Is Miss Cruz a handicapped worker? Explain. Answer: no. Low IQ or low efficiency does not make the worker handicapped. In the contemplation of law, handicap means such physical or mental infirmity that impairs capacity to work. The deficiency may also be due to age or injury. Article 78, Labor Code. Equal opportunity. Q. A lady worker was born with a physical deformity, specifically hard of hearing, speech impaired, and color blind. However, these deficiencies do not impair her working ability. Can the employer classify the lady worker as a handicapped worker so that her daily wage will only be 75% of the applicable daily minimum wage? No. The employer cannot classify the lady worker as a handicapped worker because, according to the facts in the question, her deficiencies do not impair her working ability. If her earning capacity is therefore not also impaired, then she cannot be considered a handicapped worker. Because of the above fact, the employer shall not pay her less than the applicable daily minimum wage. Article 78 of the Labor Code. Q. For humanitarian reason, a bank hired several handicapped workers to count and sort out currencies. Their employment contract was for 6 months. The bank terminated their employment on the ground that their contract has expired, prompting them to file with the labor arbiter a complaint for illegal dismissal. Will their action prosper? A. No. Article 80 provides that in case of employing handicapped workers, an employment agreement must be contracted. Article 80 further provides that such employment agreement shall contain the duration of the employment period. In the case at bar, the action will not prosper, for the bank cannot be held liable for illegal dismissal, for the handicapped employees themselves have agreed to their term of employment with only be limited to 6 months. Note, the contract signed by the workers is akin to a probationary employment, during which the bank determined the employee's fitness for the job. If the bank renewed the contract after the lapse of 6 months probationary period, the employees will then become regular employees, since the task of counting and sorting bill is necessary and desirable to the business of the bank. Bernardo et al. Versus NLRC. This is 2012 bar. The same question was asked in 2006 and 2000 bar, and the answer is yes. Citing the same case. Labor standards. Hours of work. 2004 bar. Q. Gil Bates, a computer analyst and programmer of hard drive company, works 8 hours a day for 5 days a week at the main office providing customers information technology assistance. On Saturdays, however, the company requires him to keep his cellular phone open from 8 to 5 p.m. so that the management could contact him in case of heavy workload or emergency problems needing his expertise. May said hours on Saturdays be considered compensable working hours while on call? If so, should said compensation be reported to the Social Security System? 2004. A. Said hours on Saturdays should be considered as compensable working hours while on call. In accordance with the rules and regulations implementing the Labor Code, an employee who is not required to leave work at his home or with company officials as to where he may be reached is not working while in call. But in the question, Gil Bates was required to keep his cell phone open from 8 a.m. to 5 p.m. Therefore, Bates should be considered as working while on call. If he cannot use effectively and gainfully for his own purpose the time from 8 a.m. to 5 p.m. on Saturdays when he is required to keep his cell phone open. Normal hours of work. Compressed work week. Q. Under what conditions may a compressed work week, scheduled by legally authorized as an exception to the 8-hour-a-day requirement under the Labor Code? 2005. A. Compressed work week is resorted to by the employer to prevent serious losses due to causes beyond his control, such as when there is a substantial slump in the demand for his goods or services or when there is lack of raw materials. Explanatory bulletin in the reduction of work days on wages issued by Dole, July 23, 1985. The conditions for an allowable compressed work week are the following. The workers agree to the temporary change of work schedule, and they do not suffer any loss of overtime pay, fringe benefits, or their weekly or monthly take-home pay. Overtime, 2015-2010 bar. Q. Socorro is a clerk typist in the Hospicio de San Jose, a charitable institution dependent for its existence on contributions and donations from well-wishers. She renders work 11 hours a day, but has not been given overtime pay since her place of work is a charitable institution. Is Socorro entitled to overtime pay? Yes, Socorro is entitled to overtime compensation. She does not fall under any of the exceptions to the coverage of Article 82, hours of work. The Labor Code is equally applicable to nonprofit institutions. A covered employee who works beyond 8 hours is entitled to overtime compensation. Q. A case against an employer company was filed charging it with having violated the prohibition against offsetting undertime for overtime work on another day. The complainants were able to show that pursuant to the collective bargaining agreement CBA, employees of the union had been required to work overtime on Saturday but were paid only at regular rates of pay on the thesis that they were not required to complete, and they did not in fact complete the 8-hour work period daily from Monday through Friday. Given the circumstances, the employer contends that the employees were not entitled to overtime compensation. Example, with premium rates of pay, decide the controversy. Article 88 of the Labor Code provides that undertime work on any particular day shall not be offset by overtime work on any other day. The CBA, the law between the parties and the union, has shown that the employees are required to render overtime work on Saturdays. Thus, the contention of the employer is not tenable. The employer cannot use the undertime incurred from Monday through Friday to offset the overtime on Saturday. Hence, the employees are entitled to overtime compensation and premium rates of pay on Saturday. Q. After working from 10 a.m. to 5 p.m. on a Thursday as one of 5,000 employees in a beer factory, A hurried home to catch the early evening news and have dinner with his family at around 10 p.m. of the same day. The plant manager called in and offered A to fill in for C, who missed the second shift. May A validly refuse the plant manager's directive? Explain. Yes, A may validly refuse to fill in for C. A may not be compelled to perform overtime work considering that the plant manager's directive is not for an emergency overtime work, as contemplated under Article 89 of the Labor Code. Assuming that A was made to work from 11 p.m. on Thursday until 2 a.m. on Friday, may the company argue that since he was 2 hours late in coming to work on Thursday morning, he should only be paid for work rendered from 1 a.m. to 2 a.m. Explain 2010 bar. No, undertime is not offset by overtime. Q. LKG Garments Incorporated makes baby clothes for export. As part of its measures to meet its orders, LKG requires its employees to work beyond 8 hours every day from Monday to Saturday. It pays its employees an additional 35% of their regular hourly wage for work rendered in excess of 8 hours per day. Because of additional orders, LKG now requires 2 shifts of workers, with both shifts working beyond 8 hours, but only up to a maximum of 4 hours. Carding is an employee who used to render up to 6 hours of overtime work before the change in schedule. He complains that the change adversely affects him because now he can only earn up to a maximum of 4 hours worth of overtime pay. Does carding have a cause of action against the company? 2015. No, a change in work schedule is a management prerogative of LKG. Thus, carding has no cause of action against LKG if, as a result of its change of 2 shifts, he now can only expect a maximum of 4 hours overtime work. Besides, Article 87 of the Labor Code does not guarantee carding a certain number of hours of overtime work. In Manila Jockey Employees Union versus Manila Jockey Club, the Supreme Court held that the basis of overtime claim is an employee's having been permitted to work. Otherwise, in this case, such is not demandable. Night shift differential 2002. Q. As a tireman in a gasoline station open 24 hours a day with only 5 employees, Goma worked from 10 p.m. until 7 a.m. on the following day. He claims he is entitled to night shift differential. Is he correct? Yes. Under Article 86 of the Labor Code, night shift differential shall be paid to every employee for work performed between 10 p.m. in the evening to 6 in the morning. Therefore, Goma is entitled to night shift differential for work performed from 10 p.m. until 6 a.m. of the day following. but not from 6 a.m. to 7 a.m. of the same day. Alternative answer, no. The Omnibus Rules implementing the Labor Code in Book 3, Rule 2, dealing with night shift differential, provides that its provisions on night shift differential shall not apply to employees of a retail and service establishment regularly employing not more than 5 workers. Because of this provision, Goma is not entitled to night shift differential because the gasoline station where he works has only 5 employees. Rest period, 1998. Q. A ladies' dormitory run or managed by a charitable nonprofit organization claims that it is exempt from the coverage of the weekly rest period provision of the Labor Code. Is the claim valid? No. The claim is not valid. The provisions on weekly rest period in the Labor Code cover every employer, whether operating for profit or not. Article 91 of the Labor Code. Q. Lawyer Anthony Martin recently formed a law partnership with 5 other lawyers, friends of his. They hired 2 office secretaries, an accounting clerk cashier, 1 bookkeeper, and 2 messengers. You are among 3 associate attorneys. The work week is Monday to Friday. There is no vacation leave, but sick leave is 15 days for every year of continuous and satisfactory service. Managing partner Martin is preparing a set of personal policies in terms and conditions of employment for the staff and has asked you to give him a brief memo on the questions listed below. Should the new firm schedule a rest day for the employees, including you? 1987. A. There is no need under the Labor Code to schedule a rest day. The Code, in Article 9.1, requires an employer to provide each of his employees a weekly rest day after every 6 consecutive normal weekdays. Hence, the work week is such that it is for 5 days. The Saturday and Sundays when the employees are not required to work more than satisfy the required weekly rest day. Holiday pay, 13-month pay, 2012. Q. Dennis was a taxi driver who was being paid on the boundary system basis. He worked tirelessly for Cabrera Transport Incorporated for 14 years until he was eligible for retirement. He was entitled to retirement benefits. During the entire duration of his service, Dennis was not given his 13-month pay or his service incentive leave pay. Is Dennis entitled to 13-month pay and service leave incentive pay? Explain. A. No. A taxi driver paid under the boundary system is not entitled to 13-month pay and an SIL pay. Hence, his retirement pay should be computed solely on the basis of his salary. Specifically, Section 3, letter E of the Rules and Regulations implementing PD 851 excludes from the obligation of 13-month pay employers of those who are paid on boundary basis. On the other hand, Section 1, letter D, Rule 5, Book 3 of the Omnibus Rules provide that those employees whose performance is unsupervised by the employer are not entitled to service incentive leave. A taxi driver paid under the boundary system is an unsupervised employee. B. Since he was not given his 13-month pay and service incentive leave pay, should Dennis be paid upon retirement in addition to the salary equivalent to 15 days of every year of service, the additional 2.5 days representing 1/5, 1/12 of the 13-month pay, as well as the 5 days representing the service incentive leave for a total of 22.5 days? That was asked in 2012 bar. No, since he is not entitled to 13-month pay and service incentive leave, his retirement pay should be computed solely on the basis of his salary. R&E Transport versus Latag. Q. During the open forum following your lecture before members of various union affiliated with the Labor Federation, you were asked the following questions. Araw ng Kagitingan and Good Friday are among the 10 paid regular holidays under Article 94 of the Labor Code. How much will an employee receive when both holidays fall on the same day? 2005. A. The employee will receive 200% of his regular daily wage. when both regular holidays fall on the same day and he does not work. The law provides that he shall receive his regular daily wage for each regular holiday. The employee will receive 100% for Araw ng Kagitingan and 100% for Good Friday. If he works on that day, he is entitled to 400 of his regular daily wage. Otherwise, there will be diminution of benefits. Asian Transmission Corporation versus Court of Appeals. Q. TRX, a local shipping firm, maintains a fleet of motorized boats plying the island barangays of AP, a coastal town. At day's end, the boat operators or crew members turn over to the boat owner their cash collection from cargo fees and passenger fares, less the expenses of diesel fuel, food landing fees, and spare parts. 50% of the monthly income of or earnings derived from the operations of the boats are given to the boatman by way of compensation, deducted from the individual shares of the boatmen or their cash advance and peso value of their absences, if any. Are these boatmen entitled to overtime pay, holiday pay, and 13-month pay? 2004. A. If the boatmen are considered employees like jeepney drivers paid on a bandor system, the boatmen are not entitled to overtime and holiday pay because they are workers who are paid by results. Said workers under the labor code are not entitled, among others, to overtime pay and holiday pay. In accordance with the rules and regulations implementing the 13-month pay law, however, the boatmen are entitled to the 13-month pay. Workers who are paid by result are to be paid their 13-month pay. Wages 2015, 2008, and 2010. Q. A worked as a room boy in La Mallorca Hotel. He sued for underpayment of wages before the NLRC, alleging that he was paid below the minimum wage. The employer denied any underpayment, arguing that based on long-standing, unwritten policy, the hotel provided food and lodging to its housekeeping employees, the costs of which were partly shouldered by it and the balance was charged to the employees. The employees' corresponding share in the cost was thus deducted from their wages. The employer concluded that such valid deduction naturally resulted in the payment of wages below the prescribed minimum. If you were the labor arbiter, how would you rule? 2010. I would rule in favor of A. Even if food and lodging were provided and considered as facilities by the employer could not deduct such facilities from its workers' wages without compliance with law. Mayon Hotel and Restaurant versus Adana. In Mabesa versus NLRC, the Supreme Court held that the employer simply cannot deduct the value from the employee's wages without satisfying the following. A. Proof that such facilities are customarily furnished by the trade. B. The provision of deductible facilities is voluntarily accepted in writing by the employee. And C. The facilities are charged at fair and reasonable value. Q. The rank and file union staged a strike in the company premises, which caused the disruption of business operations. The supervisors' union of the same company filed a money claim for unpaid salaries for the duration of the strike, arguing that the supervisors' failure to report for work was not attributable to them. The company contended that it was equally faultless, for the strike was not the direct consequence of any lockout or unfair labor practice. May the company be held liable for the salaries of the supervisors? 2008. No. I will apply the no work, no pay principle. The supervisors are not entitled to their money claim for unpaid salaries, as they should not be compensated for services skipped during the strike of the rank and file union. The age-old rule governing the relation between labor and capital, or management and employee, of a fair day's wage for a fair day's labor remains as the basic factor in determining employees' wages. Aklan Electric Cooperative versus NLRC. Q. Benito is the owner of an eponymous clothing brand that is a top seller. He employs a number of male and female models who wear Benito's clothes in promotional shoots and videos. His deal with the models is that Benito will pay them 3 sets of free clothes per week. Is this arrangement allowed? No. The arrangement is not allowed. The models are Benito's employees. As such, their services are required to be paid only in legal tender, even when expressly requested by the employee. Article 102 Labor Code. Hence, no lawful deal in this regard can be entered into by and between Benito and his models. The 3 sets of clothes, regardless of value, are in kind. Hence, the former's compensation is not in the form prescribed by law. Wage versus salary. Q. Distinguish salary from wage. 1994. In the case of GAA versus Court of Appeals, the Supreme Court had the opportunity to distinguish salary and wages. According to the Supreme Court, the term wages refers to the compensation given in consideration of manual labor, skilled or unskilled. On the other hand, salary denotes a compensation for a higher degree of employment. Payment of wages, 2004. Q. TRX. A local shipping firm maintains a fleet of motorized boats plying the island barangay of AP, a coastal town. At day's end, the boat operators or crew members turn over to the boat owner their cash collections from cargo fees and passenger fares, less the expenses for diesel fuel, food, landing fees, and spare parts. 50% of the monthly income or earnings derived from the operation of the boats are given to the boatmen by way of compensation. Deducted from the individual shares of the boatmen are their cash advance and peso value for their absences, if any. Are these boatmen entitled to overtime pay, holiday pay, and 13-month pay? No. The boatmen are considered as workers who are paid by results. More specifically, they are task workers who are paid not based on the number of units produced, but are paid based on the completion of their task, with appropriate deductions based on circumstances such as road and traffic conditions. Adriano Quintos et al. Versus NLRC. In the case at bar, the boatman's payment differs depending on conditions such as the increase or decrease of the price of diesel, food expenses, landing fees, and spare parts. In connection, their payment, although being direct remunerations or compensations for their service, cannot be considered as wages, for they do not partake the nature of wages as defined by laws on labor. Instead, their payment is considered as commissions, and as held by the Supreme Court in the case of King of Kings Transport versus Mamak. Workers who are paid by commissions are not entitled to the 13-month pay. I read the same question early on, and it says that in accordance with the rules and regulations implementing the 13-month pay law, however, the boatmen are entitled to 13-month pay. Workers who are paid by results are to be paid their 13-month pay. Non-diminution of benefits 2015. Q. Can an employer and an employee enter into an agreement reducing or increasing the minimum percentage provided for night differential pay, overtime pay, and premium pay 2006? No. If the agreement is with regards to reduction, Article 100 provides for the prohibition against elimination or diminution of benefits. However, if the agreement seeks to increase the minimum percentage, it is allowed because there is nothing in the law which prohibits the same. What is expressly prohibited under the law is only reduction. Q. Far Eastern Bank, FE, is one of the leading banks in the country. Its compensation and bonus packages are top of the industry. For the last 6 years, FEB had been providing the following bonuses across the board to all its employees. A. 13-month pay. B. 14th and 18th-month pay. Christmas basket worth $6,000. Gift check worth $4,000. And productivity-based incentive ranging from a 20% to 40% increase in gross monthly salary for all employees who would receive an evaluation of excellent for 3 straight quarters in the same year. Because of its poor performance overall, FEB decided to cut back on the bonuses this year and limited itself to the following: 13-month pay, 14-month pay, Christmas basket worth $4,000, and gift check worth $2,000. Katrina, an employee of FEB who had gotten a rating of excellent for the last 3 quarters, was looking forward to the bonuses plus the productivity incentive bonus. After learning that FEB had modified the bonus scheme, she objected. Is Katrina's objection justified? Katrina's objection is justified. Having enjoyed the across-the-board bonuses, Katrina has earned a vested right. Hence, none of them can be withheld or reduced. In the problem, the company has not proven its alleged losses to be substantial. Permitting reduction of pay at the slightest indication of losses is contrary to the policy of the state to afford full protection of labor and promote full employment. Linton Commercial versus Helera, October 10, 2007. As to the withheld productivity-based bonuses, Katrina is deemed to have earned them because of her excellent performance ratings for the 3 quarters. On this basis, they cannot be withheld without violating the principle of non-diminution of benefits. Moreover, it is evident from the fact of the case that what was withdrawn by FEB was the productivity bonus, protected by RA 6791, which mandates that the monetary value of the productivity improvement be shared with the employees. The productivity-based incentive scheme of FEB cannot just be withdrawn without the consent of its affected employees. Wage Order, Wage Distortion, 2009, 2008, 2006, 2002 bar. Q. When is there a wage distortion? There is a wage distortion when an increase in prescribed wage rates result in the elimination or severe contraction of intentional quantitative differences in wage or salary rates between and among employee groups in an establishment as to effectively obliterate the distinctions embodied in such wage structure based on skills, length of service, or other logical basis of differentiation. Wage distortion arises when 4 essential elements are present. A. An existing hierarchy of positions with corresponding salary rates. B. A significant change or increase in the salary rate of a lower pay class without a corresponding increase in the salary of a higher one. C. The elimination of the distinction between 2 groups or classes. In D. The distortion exists in the same region of the country. Pro Bankers Association versus Prudential Bank and Trust. Q. How should a wage distortion be settled? 2006. 2009. Any dispute arising from wage distortion shall be resolved through the grievance procedure as provided in the applicable collective bargaining agreement, and if the dispute remains unresolved, then through voluntary arbitration. In cases where there are no collective bargaining agreements or recognized labor unions, the employers and workers shall endeavor to correct such wage distortions. Any dispute arising therefrom shall be settled through the National Conciliation and Mediation Board, and if it remains unresolved after 10 calendar days of conciliation, the issue of wage distortion shall be referred to the appropriate branch of the NLRC. Q. Can the issue of wage distortion be raised in a notice of strike? Explain. 2006 and 2009 bar. A. In Ilaw ng Manggagawa versus NLRC, the Supreme Court held that any issue involving wage distortion shall not be a ground for a strike or lockout. The legislative intent is to solve wage distortion problems through voluntary negotiation or arbitration. Q. How should a wage distortion be resolved? 1. In case there is a collective bargaining agreement, and 2. In case there is none. 2002. A. According to Article 124 of the Labor Code, in case there is a collective bargaining agreement, a dispute arising from wage distortions shall be resolved through the grievance machinery provided in the CBA, and if remains unresolved, through voluntary arbitration. In case there is no collective bargaining agreement, the employers and workers shall endeavor to correct such distortions. Any dispute arising therefrom shall be settled through the National Conciliation and Mediation Board, and if it remains unresolved after 10 calendar days of conciliations, then the dispute is referred to the appropriate branch of the National Labor Relations Commissions. Service Incentive Leave, 2012-2010. Q. A driver for a bus company sued his employer for non-payment of commutable service incentive leave credits upon his resignation after 5 years of employment. The bus company argued that A was not entitled to service incentive leave since he was considered a field personnel and was paid on commission basis, and that, in any event, his claim had prescribed. If you were the labor arbiter, how would you rule? 2010. I will grant the prayer of A. Payment on commission basis alone does not prove that A is a field personnel. There must be proof that A is left to perform his work unsupervised by his employer. Otherwise, he is not a field personnel, thus entitled to commutable service incentive leave (SIL) credits. Autobus versus Bautista. His action has not yet prescribed. In Autobus versus Bautista, the Supreme Court recognized that SIL is such a unique labor standard benefit because it is commutable. An employee may claim his accrued SIL throughout the years of his service with the company upon his resignation, retirement, or termination. Therefore, when A resigned after 5 years, his right of action to claim all his SIL benefits accrued at the time when the employer refused to pay him his rightful SIL benefits. Article 291, Labor Code. Maternity leave, 2010. Q. A. Single, has been an active member of the Social Security system for the past 20 months. She became pregnant out of wedlock, and on her 7th month of pregnancy, she was informed that she would have to deliver the baby through cesarean section because of some complications. Can A claim maternity benefits? If yes, how many days can she go on maternity leave? If not, why is she not entitled? 2010. Yes, the SSS law does not discriminate based on the civil status of a female member employee, as long as said female employee has paid at least 3 monthly contributions in the 12-month period immediately preceding the semester of her childbirth. She can avail of the maternity benefits under the law. Since A gave birth to cesarean, she is entitled to 100% of her average salary credit for 78 days, provided she notifies her employer of her pregnancy and the probable date of her childbirth, among others. Section 14-A, Republic Act 8282. The same maternity benefits are ensured by Section 22, letter B, number 2 of the Magna Carta of Women. Q. AB, single and living in with CD, a married man, is pregnant with her 5th child. She applied for maternity leave, but her employer refused the application because she is not married. Who is right? Decide. AB is right. The Social Security law, which administers the maternity benefit program, does not require that the relationship between the father and the mother of the child be legitimate. The law is compensating the female worker because of her maternal function and resultant loss of compensation. The law is morality-free. Q. Mans Weto had been an employee of Nopal Assurance Company for the last 10 years. His wife of 6 years died last year. They had 4 children. He then fell in love with Jovi, his co-employee, and they got married. In October this year, Wito's new wife is expected to give birth to her first child. He has accordingly filed his application for paternity leave, conformably with the provisions of the paternity leave law, which took effect in 1996. The HRD manager of the assurance firm denied his application on the ground that Wito had already used up his entitlement under that law. Wito argued that he has a new wife who will be giving birth for the first time. Therefore, his entitlement to paternity leave benefits would begin to run anew. Is Jovi entitled to maternity leave benefits? 2005. Yes, if Jovi as a female employee has paid at least 3 monthly contributions in the 12-month period immediately preceding the semester of her childbirth, she is entitled. How about Mansueto? Is his contention on his entitlement to paternity leave correct? The contention of Wito is correct. The law provides that every married male is entitled to a paternity leave of 7 days for the first 4 deliveries of the legitimate spouse with whom he is cohabiting. Jovi is Wito's legitimate spouse with whom he is cohabiting. The fact that Jovi is his second wife and that Wito had 4 children with his first wife is beside the point. The important fact is that this is the first child of Jovi with Wito. The law did not distinguish, and we should therefore not distinguish. The paternity leave was intended to enable the husband to effectively lend support to his wife in her period of recovery in the nursing of the newly born baby. To deny veto his benefit would be to defeat the rationale of the law. Q. How many times may a male employee go on paternity leave? Can he avail himself of this benefit, for example, 50 days after the first delivery by his wife? A male employee may go on paternity leave up to 4 children. On the question of whether or not he can avail himself of this benefit 50 days after the delivery of his wife, the answer is yes, he can, because the rules implementing Paternity Leave Act says that the availment should not be later than 60 days after the date of delivery. Special Leave for Women Workers, Magna Carta for Women, 2013. Q. Because of the stress in caring for her 4 growing children, Tammy suffered a miscarriage late in her pregnancy and had to undergo an operation. In the course of the operation, her obstetrician further discovered a suspicious-looking mass that required the subsequent removal of her uterus, hysterectomy. After surgery, her physician advised Tammy to be on full bed rest for 6 weeks. Meanwhile, the biopsy of the sample tissue taken from the mass in Tammy's uterus showed a beginning malignancy that required an immediate series of chemotherapy once a week for 4 weeks. What benefits can Tammy claim under existing social legislation, 2013? Assuming she is employed, Tammy is entitled to a special leave benefit of 2 months with full pay. Pursuant to RA 9710 or the Magna Carta of Women, she can also claim sickness leave benefit in accordance with SSS law.